Judge spoke Latin to humiliate the girl. Seconds later, the court fell silent. The laughter started before she even finished saying her name. She had spoken it clearly, the way she had been taught to speak in rooms like this one. Steady, without apology, chin level. Nora Callahan, 22 years old, standing in orange, hands locked together at the wrist by a pair of handcuffs that were slightly too tight and had left a faint red mark on her left wrist that she could feel but could not see. The jumpsuit was 2 sizes too large and smelled of industrial detergent and something underneath the detergent that she preferred not to identify. Her hair, which she had once spent considerable time maintaining, was pulled back in a rough elastic band that a corrections officer had given her that morning without looking at her face. She had been in the county detention center for 11 days. 11 days in a room with 4 other women, a toilet with no curtain, and fluorescent lights that never fully turned off. 11 days of waiting for this moment, which was supposed to be her arraignment hearing, a brief procedural appearance during which her charges would be formally read, and she would enter a plea and a bail determination would be made. Routine. That was the word the corrections officer had used when she asked what to expect. It would be routine. She had used the 11 days. Not to despair, though despair had visited, briefly and persistently, in the hours between 2 and 4 in the morning, when the facility was as quiet as it ever got, and the certainty that the truth would eventually be recognized felt most fragile. She had used them to think, to reconstruct from memory the transaction sequence she had flagged before her arrest, to map the timeline, to identify the specific technical details that would be necessary to make an argument that could not be dismissed as the self-serving narrative of someone accused. She did not have access to any of the actual files. She had her memory, which was excellent, and a borrowed pen and time. She had spent the time the way she spent everything, methodically, without rushing the conclusion before the analysis was complete. By the time the 11 days were over, and she was standing in a courtroom being laughed at by a judge, she had 3 handwritten pages in a folder and a clarity about the facts of her situation that was more complete than anything in the prosecution's 4-page summary. She was waiting, with a patience that had been built out of 11 days of practice, for the right moment to offer it to someone capable of doing something with it. Judge Gerald Macon had been on the bench for 19 years. He was a heavy-set man with a shaved head and small, bright eyes that moved quickly across whatever was in front of him. Documents, people, the middle distance, with equal speed and unequal attention. He had the laugh of a man who found himself reliably funny, a full-bodied, unself-conscious sound that filled whatever room he was in and expected the room to receive it as a gift. In his courtroom, most people treated it that way. In his courtroom, most people treated most things the way he expected them to be treated, because 19 years on the bench had given Gerald Macon a comprehensive understanding of which rooms in the world belonged to him. And this one did, unambiguously, completely, and in a way that he had long since stopped needing to remind anyone of. The courtroom itself was the kind of room that communicated authority through its materials. Dark wood paneling that rose to within 2 feet of the ceiling. Brass fixtures worn smooth by decades of hands that had touched them with the solemnity of proximity to judgment. The elevated bench where Macon sat was not merely furniture. It was architecture designed to produce a specific psychological effect in the people who stood before it, the effect of smallness, of looking upward, of understanding without being told that the space between the bench and the floor was not merely physical distance, but the distance between those who decided and those who were decided upon. Macon had never consciously reflected on this. He had sat above it long enough that the arrangement seemed to him simply natural. The way things were, the way things should be. The charge against Nora was grand theft, specifically the alleged theft of $68,000 from the accounting department of a mid-sized logistics company where she had been employed as a junior financial analyst for 14 months. The company's legal team had filed the complaint. The arrest had followed within a week. The case, on paper, looked clean and prosecutorial. Irregular transactions, an access log showing her credentials, a series of transfers that routed through an account she had opened 6 years earlier as a college student. What the paper did not show, because no one had looked for it yet, was anything else. The paper did not show the memo she had written. It did not show the meeting she had requested. It did not show the conversation with her supervisor that had lasted 9 minutes and had ended with her being told, in language professionally calibrated to communicate finality without hostility, that the matter was being reviewed internally and that her role did not include making formal flags outside her area of direct responsibility. It did not show the 2 weeks between that meeting and her arrest, during which she had continued working as if nothing had changed, because nothing that she could see had changed, and because the alternative, which was to assume that the meeting had been the beginning of something aimed at her, had seemed too paranoid to act on until the moment the paramedics arrived with handcuffs, and it suddenly seemed like the only reasonable interpretation. Nora's public defender was a man named Thomas Wick, who had been practicing law for 3 years and was currently managing 31 active cases. He was not incompetent. He was not indifferent. He was 31 cases deep in a system that allocated public defense resources with the same generosity it allocated everything else to people who could not afford to purchase something better, which is to say, barely enough and just late enough to matter. He had reviewed Nora's file for 40 minutes the previous evening. He had identified several questions he would want answered before trial. He had not yet had time to begin answering them. What Wick did not know, and had not taken the time to learn, was the texture of who Nora Callahan actually was beneath the charge sheet. He did not know that she had graduated summa cum laude, that her undergraduate thesis had been cited in 2 subsequent academic papers, that she had turned down a fully funded doctoral program to take the analyst position because she had been supporting her younger brother through his last 2 years of college and needed the salary rather than the stipend. That she had accepted the job at the logistics company not because it was her ambition, but because it was available and decent, and she was methodical enough to be good at it even when it bored her, which was frequently. That in the 14 months she had worked there, she had been quietly building the analysis skills the job required into something that extended well past the job's own requirements. Because that was the way she approached things, with more attention and precision than the situation technically demanded, because anything less felt, to her, like a kind of intellectual dishonesty she was not willing to practice. He did not know any of this. He had 40 minutes and the charge sheet and 30 other cases waiting. He was seated at the defense table when Nora was brought in, and he nodded at her with the efficient warmth of a man who meant well and was operating 5 minutes behind where he needed to be. She nodded back and took her place beside him at the table and waited, with the particular stillness of someone who had learned in 11 days that stillness was the only form of control available to her. The prosecution was represented by an assistant district attorney named Paul Sheridan, who was thorough, well-prepared, and had a talent for presenting financial crime narratives in language plain enough for any jury to follow and damning enough to make the defendant's guilt feel like gravity, inevitable, already present, simply waiting to be confirmed. He had prepared a summary of the charges that ran to 4 pages and was supported by a transaction analysis that the accounting department's forensic auditor had produced in 72 hours. Sheridan believed Nora was guilty. He believed it with the quiet, settled confidence of someone who has reviewed a financial trail and found it pointed in one direction. He was not the kind of man who constructed narratives from nothing. He was the kind of man who followed evidence, and the evidence as he had received it, pointed clearly. What Sheridan did not know, because the evidence he had received had been assembled by people with a significant interest in the direction it pointed, was that he was working from an incomplete picture. He would find this out later, but that morning, in that courtroom, with the transaction log and the access records and the account documentation laid out in front of him in 4 clean pages, he had no reason to look for what was missing. Judge Macon called the case at 9:47. He had already read the summary. He was holding the 4 pages loosely in one hand when Nora was brought to stand before the bench, and he looked at her with the brief, practiced assessment of a man who had processed a very large number of defendants and had developed, over 19 years, a fast and reliable method of placing them into categories that would govern the pace and tone of the proceeding that followed. The category he placed Nora in was visible in the half-second before he looked back down at his papers. It was not hostile exactly. It was something more insidious. It was the category of the already explained. He had seen the charges. He had seen the amount. He had seen the employment record and the account details. He had formed a shape in his mind before she opened her mouth, and the shape was not favorable, and it was not going to be easily revised by anything so minor as her presence in the room. Wick stood and introduced himself. Sheridan stood and introduced himself. The charges were read. Nora listened to each one with her eyes forward and her hands quiet on the table in front of her. When the reading finished, Macon leaned back in his chair and looked at Nora over the rims of his reading glasses, with the particular look of a man who is about to say something he considers clever. It was an expression his clerk, a young man named Davis, who had worked with him for 14 months, recognized with a quiet internal contraction. It was the expression that preceded what Macon called education, what Davis privately called performance. "Ms. Callahan," Macon said, "before we proceed, your file indicates you have a degree in classics from the university. Is that correct?" The question was unexpected enough that Wick looked up from his notes. Sheridan's pen paused above his legal pad. Nora met the judge's eyes directly. "Yes, Your Honor." "Latin and Greek, ancient literature, philosophy." He smiled in the direction of the papers in his hand, as though they had said something amusing. "Impressive. And yet here we are." He looked up. "Tell me, Miss Callahan, are you familiar with the phrase furtum manifestum?" The smile widened slightly. It was aimed at Sheridan, who produced a small, professionally obligated upturn of the corner of his mouth. Davis looked at the surface of his desk. "Furtum manifestum, manifest theft, Roman law. The term applied to a thief caught in the act, taken with the stolen goods still in hand. It was a specific legal concept from the 12 Tables, the foundational legal code of the Roman Republic, carrying historically the harshest penalties available under ancient jurisprudence. Macon had deployed it the way a man deploys a specialized instrument to remind the room of the breadth of his own toolbox. The message was theatrical and precise. "I know your field. I know it better than you. And I am using it against you." It was designed to humiliate. Everyone in the room understood that. The bailiff understood it. Davis understood it. Sheridan understood it. And the discomfort of that understanding was visible in the slight shift of his weight from one foot to the other. Wick understood it and opened his mouth to object on grounds he was still formulating. What Macon had not accounted for, because there was no reason based on the file in his hand to account for it, was that the young woman in the orange jumpsuit standing before him had spent 4 years inside the original language of that term, not as a tourist, but as a scholar who had lived inside Roman legal text the way you live inside a second country. She had read the 12 Tables in Latin. She had read the Digest in Latin. She had written her undergraduate thesis on the procedural distinctions between manifest and non-manifest theft in classical Roman jurisprudence and its evolution through Justinian's codification. She had done this not in translation, not in the sanitized English of secondary scholarship, but in the original language, with its precise vocabulary and its carefully maintained technical distinctions. And the precision was not decorative. It was functional. It was the difference between a person who has heard a word used and a person who knows exactly what it means. Macon had brought a knife to what turned out to be a conversation about knives. But Nora spoke first. She did not raise her voice. She did not adjust her posture. She simply looked at Judge Gerald Macon with a steadiness that was entirely without performance and said in Latin as clean and unaccented as running water, "Immo, iudex, furtum manifestum propriae dicitur cum fur in ipso actu deprehenditur, quod hic non adest." The courtroom went silent, not the polite silence of a room waiting for the next thing to happen. The silence of a room that has just heard something that has displaced the air in a way that requires a moment of recalibration before anyone can speak. The translation, for everyone present who did not already know, was precise and complete. Actually, Your Honor, furtum manifestum properly refers to a thief caught in the very act, which is not the case here. Macon stared at her. The smile was still technically on his face, but it had lost its structural support. It was the face of a man whose joke has been answered in kind, in the original language, with a correction attached. Davis did not look up from his desk, but something in the set of his shoulders changed. Sheridan set his pen down very carefully. Wick, who had been sitting with his mouth slightly open, closed it. Nora waited. She was very good at waiting. Macon cleared his throat. "Miss Callahan," he said, and his voice had recovered most of its authoritative register. "I appreciate the lesson. However, the court—" "I also know the phrase," Nora said, and she said it with a courtesy so meticulous it had no room for anything to be read into it. "Furta non sunt admittenda nisi probata. Thefts are not to be admitted unless proven." That one is from the Digest, Title 47. The silence that followed was longer than the first one. Somewhere in the gallery, someone coughed. The sound was very loud in the absence of anything else. Macon looked down at the papers in his hand. He looked at them with the focus of a man who is using the act of reading to give himself a moment he needs. Then he looked at Wick. Then at Sheridan. Then, with a measuredly neutral expression that had replaced whatever had been there before, back at Nora. "We'll take a 10-minute recess," he said. He stood. Davis was already on his feet. The bailiff called the room to order and then to recess, and the room released itself from the held breath of the previous 60 seconds in a collective, audible exhale. Wick turned to Nora. He looked at her for a moment with an expression that had several layers moving beneath its surface. "Classics degree," he said. "Concentration in Roman law," Nora said, "with a minor in medieval legal history." Wick nodded slowly. Then he looked at the table. Then he looked at her again. "You should have told me that." "I tried to," she said. "In the intake form, there was a section for relevant background. I wrote 4 paragraphs. Wick said nothing. He looked at his briefcase. The intake form was in there somewhere. He knew, with a certainty that landed heavily, that he had not read the intake form. He had read the charge sheet. He had read the transaction summary. He had intended to read the intake form and had not gotten there. "I'll need to see everything you wrote," he said. "I know," she said, and in the 2 words there was no accusation. Only the patient precision of someone who had been waiting 11 days for this conversation to begin. In the 10 minutes that followed, while the courtroom murmured around them and Macon sat in his chambers with a glass of water and an expression his secretary would describe later as unusually careful, Nora Callahan opened the small folder she had been allowed to bring from the detention center and placed 3 handwritten pages on the table in front of Thomas Wick. The pages contained, in a compressed and organized hand, the full account of what she believed had actually happened to the $68,000. It was not a denial, it was an analysis. It traced the transaction pattern not as the prosecution had traced it, which was linearly from authorization to transfer to account, but laterally across multiple accounts and access logs that the initial forensic audit had not cross-referenced. It identified 3 anomalies in the timing of the transactions that were inconsistent with Nora's documented physical location on 2 of the relevant dates. It noted that her credentials had been used to authorize a transaction at 11:43 p.m. on a Tuesday in November, at which time she had been, with 12 witnesses and a venue check-in record, at a concert 40 miles from the office. It also identified, in the final paragraph, a pattern that she had noticed 6 weeks before her arrest while reviewing a routine expense reconciliation. A pattern that she had flagged to her direct supervisor, a pattern that her supervisor had told her in a brief and oddly final meeting was not her concern. Her supervisor's name was Richard Gale. He had been with the company for 11 years. He had full administrative access to the accounting system, including the ability to log actions under subordinate credentials without generating a secondary authentication request. A permission level that the forensic auditor had not noted in the initial analysis, because it was a legacy permission structure that predated the current IT documentation standards and was therefore not included in the system access report that had been provided to law enforcement. Wick read all 3 pages. He read them twice. By the time the bailiff announced that court was resuming, he had written 12 questions on his legal pad and had the focused, slightly urgent expression of a man who has just understood that the case he thought he was managing is a significantly different case than the one he is actually holding. Nora watched him read. She had written those pages on the 4th day of her detention, in the 2 hours between lights on and breakfast, using a pen borrowed from the officer on duty and the back of an informational pamphlet about detainee rights. She had been composing them in her head since the night of her arrest, sorting and organizing the information in the particular way she organized everything, which was from the structure outward, framework first, then evidence, then implication. It was the way she had been trained to read ancient texts. Find the architecture of the argument before you engage with its surface. She had been waiting for someone with the standing to act on what was in those pages. She had waited 11 days. She was prepared to wait longer if necessary. But she had not expected the waiting to be interrupted, of all things, by a judge's attempt to use her own field as a weapon against her. And she had not expected her response to it to produce the particular quality of silence that had just filled this room. She had not planned the Latin. It had arrived the way the right word always arrives when you have spent enough time in a language, not as a decision, but as an inevitability. The judge had opened a door that led somewhere he had not intended to go, and Nora had simply walked through it. Now, as the recess ended and the room reassembled itself around the business of justice, something had shifted. Not everything. Not yet. The charges were still on paper. The handcuffs were still on her wrists. The 11 days were still in her body, in the way that 11 days in a fluorescent room always leave something behind. But in the room, in the air of it, in the particular way that Wick was now sitting at the table, and the way that Sheridan was now looking at his transaction summary with an expression that had become, in the space of a recess, considerably less settled than it had been. Something real had moved. The hearing resumed. Macon took his seat with a deliberateness that was notably different from the loose authority of his entrance. He looked at the papers in front of him. He looked at Nora. He did not look at her the way he had looked at her before. The look before had been the look of conclusion. This one was the look of a man who has been reminded, in an inconvenient way, that the distance between assumption and fact can be considerable. He asked Wick to speak to the question of bail. Wick stood. He was, in this moment, a better version of himself than he had been 40 minutes ago. Not more experienced, not more resourced, but more present, more attentive to the specific human case standing beside him rather than the general procedural shape it had been allowed to take. He spoke about Nora's ties to the community, her employment history, her academic record, her clean prior record, which was as clean as a record can be, meaning it contained nothing, not a parking violation, not a citation, nothing that could be made to carry weight on the prosecution's side of the scale. He noted the absence of flight risk indicators. He noted that his client had been in custody for 11 days without legal incident and had, during that time, produced documentation that he believed would be material to the evidentiary questions at the heart of the case. Sheridan objected to the materiality claim on grounds that the documentation had not been submitted for review. Wick acknowledged this and requested the opportunity to submit it formally and requested a continuance pending review of new information material to the defense. He said this clearly and without the apologetic hedging that sometimes crept into his voice when he was uncertain of his footing. He was not uncertain now. He had 3 handwritten pages in front of him and 12 questions on his legal pad and the beginning of an understanding that the case he was managing was not a case about a junior analyst who had stolen money. It was a case about a junior analyst who had found something she was not supposed to find and had been handed the consequences of finding it. Macon looked at both attorneys for a moment. The courtroom was quiet in the particular way that courtrooms go quiet when a judge is making a decision that everyone present understands is more consequential than the procedural terms being used to describe it. "The court will grant a continuance of 14 days, he said. "Bail is set at $25,000, personal recognizance bond. Ms. Callahan is to surrender her passport and remain within the jurisdiction." He paused. "The defense is directed to submit all reference documentation to the court and to the prosecution within 48 hours. He looked at Nora one more time. It was a different look than either of the ones that had preceded it. It was not warm. Gerald Macon was not a warm man, and 19 years on the bench had not made him one. But it was a look that acknowledged, in its own careful way, that the person standing before him was not what he had assumed, and that the proceeding before his court was not what the 4 pages in his hand had suggested it would be. He picked up his gavel. He set it down without striking it. "We're adjourned," he said. Thomas Wick did not go home that evening. He sat in his office until 11:30 at night with Nora's 3 handwritten pages, the transaction summary from the prosecution's forensic auditor, and a growing stack of notes that had expanded from 12 questions to 37. He ordered food he did not eat. He drank coffee that went cold. He called a contact from law school who now worked in digital forensics and left a message that was longer and more urgent than he had intended, his voice carrying the particular register of a man who has just understood that the thing in front of him is larger and more serious than the container he had been keeping it in. What Nora had written was not the emotional plea of someone wrongly accused. He had read enough of those to know the difference. It was a structured, technically precise argument built from specific and verifiable details, and every detail she had included was the kind of detail that either checked out or didn't, with nothing in between. There were no vague claims, no interpretive leaps, no appeal to his sympathy. Only, here is the date. Here is the time. Here is the transaction record. Here is my documented location. Here is the name of the system permission that makes the discrepancy possible. And here is the name of the man who held that permission, Richard Gale. Wick wrote the name on a separate page and circled it and put 3 question marks beside it. He knew, having practiced law for 3 years, that the existence of an alternative explanation was not the same as proof of innocence, and that a financial crime case with a clean digital trail pointing at one person would not simply reroute itself because that person had produced a handwritten theory. The forensic audit would need to be redone. The system permission structure would need to be independently verified. The access logs would need to be pulled with a different methodology. These were not small tasks, and they required resources that the Public Defender's Office did not casually have available. But they were tasks that could be done. And more importantly, they were tasks that, if the results confirmed what Nora's pages suggested, would completely redefine the prosecutorial narrative that had put her in handcuffs 11 days ago and was currently preparing to put her in front of a jury. He called the forensic contact again at 7 in the morning. This time the call was answered. The contact's name was Renata Cruz, and she had the quick, organized intelligence of someone who lived inside data the way other people lived inside language. Wick described the case in 10 minutes. Renata asked 4 questions. Her 4th question was about the legacy permission structure. And when Wick read her Nora's description of it directly from the handwritten pages, Renata was quiet for a moment and then said, in the considered tone of someone choosing words carefully, that if what Nora had described was accurate, the initial audit had a significant methodological gap, and the transaction attribution in the prosecution's summary could not be considered reliable. Wick had been practicing law for 3 years, which was long enough to have developed a working sense of the difference between a defense theory that was plausible and one that was structurally sound. Plausible theories were the currency of desperate cases, the inventive constructions that could create reasonable doubt in a jury without necessarily being true. Structurally sound theories were different. They were built from the internal logic of the evidence itself, from the way the pieces fit or failed to fit, and they were harder to dismiss because dismissing them required engaging with the specific technical details rather than the general plausibility of the narrative. What Nora had written was structurally sound. He could feel this the way you feel the difference between a floor that holds and one that has a soft spot, not by looking at it, but by putting your weight on it and noticing what happens. Her argument held weight. Every specific claim she had made was either independently verifiable or it wasn't. And the ones she had made with the most confidence were the ones that would be easiest to check, which meant she either knew they would check out or she was not thinking clearly. And everything about the 3 pages suggested she was thinking very clearly indeed. He filed the subpoena application before noon. "I'd need access to the system logs," she said. "Full access, not the curated export that goes to law enforcement. The full log, with timestamps on system-level events, not just user-facing actions." "If I can get you a subpoena for it?" "Then yes," she said. Wick filed the subpoena application before noon. He also filed a formal motion to expand the discovery record to include the system permission documentation that had been omitted from the initial audit materials. He wrote the motion in the careful, specific language of someone who has learned recently and forcibly the difference between a motion that gestures at an argument and a motion that makes one. He cited the access log discrepancy. He cited the timing anomaly on the November transaction. He cited the absence of the legacy permission structure from the prosecution's system access report. He did not speculate. He identified. He documented. He submitted. Sheridan received the motion and read it the same afternoon. He was a thorough man, and thoroughness in this case meant he could not dismiss the motion as a defense maneuver without first verifying the claims it contained. He called the company's forensic auditor. The auditor was initially defensive then, as Sheridan walked through the specific points in the motion. Progressively less so. The conversation ended with a silence on the auditor's end that Sheridan recognized from long professional experience as the silence of someone recalibrating. He did not call Nora's supervisor. Not yet. He sat with the motion and his notes and a growing sense of professional unease that was not comfortable but was important. He had presented cases before that turned out to be more complicated than the initial evidence suggested. He had also presented cases where the initial evidence was correct and the defense's alternative narrative was a well-constructed diversion. His job was to follow the evidence wherever it went, and right now, the evidence was going somewhere he had not expected. He authorized full cooperation with the expanded discovery request. It was the right thing to do procedurally. It was also, he understood, the right thing to do in terms of the particular case he found himself in, which was starting to look like something that, if he pursued it aggressively to a conviction without examining the questions the defense had raised, could become the kind of case that defined the wrong kind of career moment. The subpoenaed system logs arrived 8 days into the 14-day continuance period. Renata Cruz had them for 40 hours. When she called Wick, her voice had the quality of someone delivering information that is both precisely what was expected and still somehow startling to say out loud. The legacy permission structure existed exactly as Nora had described it. Richard Gale held it. It allowed system-level actions to be logged under the credentials of any analyst in the department without generating an authentication flag. The November transaction had been authorized through this mechanism. So had 4 of the 7 other transactions at the center of the prosecution's case. The timestamps on the system-level events showed activity originating from Gale's authenticated session at times that did not correspond to Nora's documented access patterns. In 2 instances, Nora's swipe card data from the building's security system showed her absent from the premises when her credentials were recorded as active in the accounting system. Wick sat with the report for a long time before calling anyone. He read it twice, then a 3rd time, looking for the thing that would make it less clear than it appeared. The thing was not there. The report was what it was. He called Sheridan that afternoon. The conversation was 30 minutes long and conducted entirely in the flat, careful language of 2 professionals managing significant information through a narrow professional channel. When it was over, Sheridan sat at his desk and wrote a memo to his supervisor. The memo described the evidentiary situation with the same flat precision. It recommended a full review of the case before proceeding to trial. It also recommended, in a final paragraph that Sheridan wrote and then deleted and then rewrote with slightly different phrasing, that the company's access log administration practices and Richard Gale's role in relation to the $68,000 be examined by law enforcement independent of the company's internal audit team. The recommendation was followed. Richard Gale was placed on administrative leave 12 days later. 11 days after that, following a more comprehensive forensic review conducted by an independent firm under law enforcement supervision, he was arrested on charges that included financial fraud, evidence tampering, and computer fraud in relation to the unauthorized use of subordinate employee credentials to conduct and conceal unauthorized transactions. The company's internal accounting irregularities, it emerged, went significantly beyond the $68,000 that had been attributed to Nora. The total figure, once the expanded audit was complete, was closer to $400,000, accumulated over 22 months. Gale had been methodical about it. He had understood the permission structure well enough to know that actions conducted through it were unlikely to be flagged in any standard audit, because the standard audit process was built on the assumption that system-level events were reliable proxies for user actions. He had also understood, with the specific precision of a person who has been inside an institution long enough to know which parts of it are not watched, that flagged concerns raised by junior analysts in informal meetings were unlikely to be escalated if the analyst could be removed from the situation before the concern became a formal record. He had done what people in his position often do when the thing most likely to protect them is the vulnerability of someone else. He had used the system against her, precisely and deliberately, relying on the system's own tendency to accept the simpler explanation over the more complicated one. It had very nearly worked. It had worked for 11 days. It had worked through an arraignment at which a judge had laughed at the person it was designed to destroy. It had very nearly continued working right up to the moment a junior analyst in an orange jumpsuit, who had spent 11 fluorescent nights turning the facts over in her mind with the patience of someone who understood that precision is a form of survival, had placed 3 handwritten pages on a table in front of the one attorney who happened to be present to receive them. The charges against Nora were formally dropped on a Thursday morning without ceremony in a brief notice filed with the court. There was no hearing. There was no public acknowledgement. A document was filed, a notation was entered into the record, and the case that had put her in handcuffs and an orange jumpsuit and a fluorescent room for 11 days ceased to exist, administratively, as if it had simply been an error to be corrected. Nora received the call from Wick while she was at her kitchen table eating breakfast. She had been released on the personal recognizance bond 9 days after the arraignment, and in the days since she had been living in the specific suspension of someone waiting for the institutional machinery to finish processing a truth it had not initially wanted to process. She had returned to most of the practical business of her life. She had not returned to anything that required certainty about her future, because certainty about her future had been one of the things the 11 days had taken with it when they left. She said thank you to Wick in the straightforward way she said most things. He said it was her work that had made it possible, and he said it in a way that was true rather than polite. She acknowledged this, and they ended the call, and she sat for a moment in the quiet of her kitchen with her coffee and the particular kind of silence that follows the end of something that should never have begun. She thought about the courtroom. She thought about the judge's laugh, the way it had moved through the room before settling on her as its target. She thought about Courtroom manifestum and the specific pleasure Macon had taken in deploying it, the pleasure of a man using another person's field as an instrument of their diminishment. She thought about the Latin that had come out of her in response, not planned, not weaponized, simply accurate, a correction stated in the language of the argument itself. And she thought about the silence that had followed it. That silence had been the first real thing to happen in that courtroom. Everything before it had been performance, institutional choreography, the proceeding moving along the tracks of its assumptions without examining whether the tracks led anywhere true. The silence had been the moment the choreography stopped and something real entered the room, something that could not be managed or categorized or dismissed with a laugh. She had not felt victorious in that moment. She had felt more than anything tired in the particular way that comes from having the truth and being in a room that is not yet ready to receive it. The Latin had not been a victory. It had been a door. What mattered was what had walked through it afterward. Wick's changed attention, Sheridan's procedural honesty, Renata's methodical precision, the subpoena, the logs, the timestamps, the report. The Latin had opened a door. The people who walked through it had done the rest. She thought also about the bailiff, who had watched all of it from the corner of the room and had said nothing, whose expression she had not been able to read from where she stood. She thought about Davis, the clerk, whose careful avoidance of eye contact during the Courtroom manifestum moment had been, she understood now, not indifference, but something closer to its opposite. She thought about the other women in the detention facility, the 4 of them in the fluorescent room, who had asked her on the 3rd night what she was in for and had listened to her answer, with the thoughtful, unsentimental attention of people who had developed a very precise instrument for detecting the difference between a story that had the texture of truth and one that did not. They had believed her. They had not been able to help her, but they had believed her, and in 11 days that had mattered more than she had expected anything so small to matter. She did not return to the logistics company. She did not want to. She spent the weeks that followed her case's dismissal doing 2 things: completing a paper she had begun writing 18 months earlier on evidentiary standards in Roman law and their parallels in contemporary procedural jurisprudence, and sending formal written complaints about the initial audit's methodological failures to the Forensic Accounting Association that had certified the auditor's firm. The paper was accepted for publication by a law review journal 3 months later. The complaint resulted in a formal review of the auditing firm's methodology, which identified systemic gaps in their standard protocol for examining legacy permission structures in enterprise accounting systems, and resulted in a revised certification requirement that would affect how future audits were conducted. Neither of these things was satisfying in the way that justice is supposed to be satisfying in stories. They were small and procedural and required the reader to care about the difference between certification protocols and standard practice, which most readers did not. But they were real and they were permanent. And they changed the specific technical landscape in ways that would prevent the specific technical failure that had put Nora in handcuffs from being as easily repeated. Judge Gerald Macon continued on the bench. There was no formal complaint filed against him for the Furtum Manifestum moment. What had happened technically fell within the broad and forgiving latitude that judicial conduct standards extended to rhetorical choices made during proceedings. He had not falsified anything. He had not influenced the outcome through improper channels. He had made a joke at a defendant's expense. This was, in the technical language of the standards, not sufficient grounds for action. But he knew what had happened, and in knowing it, in sitting with the specific memory of a young woman in handcuffs correcting him in the language he had used to humiliate her, and in knowing that the case behind the woman had turned out to be what it turned out to be, he was subject to a different kind of consequence, not institutional, not public, but real in the way that real things are real, inside the conscience of a person who has enough of one to receive what the experience was actually saying. He did not laugh in the courtroom the way he had laughed before. Not in the weeks that followed, not in the months, not in the next several years that Wick's public defender colleagues mentioned, in passing conversations, noticing the change without connecting it to a specific cause. It was not performance. It was not an overcorrection. It was simply that a habit had been interrupted by a moment precise enough to break it, and the habit had not returned in its original form. Davis, the clerk, noticed. He had been waiting for something to shift in that courtroom since his first week on the job. He did not say anything about it. He simply did his work with the same quiet efficiency and allowed the shifted room to be what it now was, which was slightly less certain of itself, slightly more attentive, slightly more willing to let the space between assumption and evidence remain open a little longer before closing. Nora defended her doctoral dissertation 2.5 years later. It was an examination of how the Roman legal concept of manifest proof had evolved through medieval ecclesiastical courts and influenced early modern evidentiary standards, with a final chapter examining its residual presence in contemporary judicial practice. Her committee was composed of 3 scholars who were not easy to impress. They were impressed. The dissertation was described in their formal assessment as a significant contribution to the field and a model of methodological rigor. The final chapter was the one that had been hardest to write, not because the material was unfamiliar, but because writing it required her to hold 2 things at the same time. The intellectual argument, which was rigorous and sourced and impersonal in the way scholarship is supposed to be impersonal, and the lived experience that had made the argument feel not merely interesting but necessary. She had managed it by keeping them separate on the page, letting the argument stand entirely on its own evidence, and trusting that the reader who knew her story would feel the connection without her needing to make it explicit, and that the reader who did not know it would find the argument sufficient on its own terms. This was, she thought, the best possible version of what her classical education had given her. The ability to hold the personal and the analytical in proximity without collapsing one into the other. Roman jurists had been doing this for centuries. The precision of the law was not the absence of the human, it was the discipline applied to the human, so that what emerged from the collision was something that could be handed forward, used, built upon. She was doing the same thing. She was handing forward the precision of an argument that had emerged from a collision she had not chosen, but had survived with enough of herself intact to make something useful out of it. She did not mention the arraignment in the dissertation. She did not mention Judge Macon, or Furtum Manifestum, or the 11 days, or the handcuffs, or the orange jumpsuit. Those things existed in a different register than scholarship, and she kept them there, carefully, in their own place. But in the acknowledgements, she thanked Thomas Wick. She thanked Renata Cruz. She thanked, without naming her specifically, a person she described only as a colleague, whose careful observation of an irregularity, though it cost her considerably, set in motion everything that followed. This was a researcher at the company who had independently flagged the same pattern Nora had found, and had done so in writing, in an internal memo 7 weeks before Nora's arrest, and whose memo had been archived in a folder that the initial investigation had not opened. The memo surfaced in the discovery process. It had Nora's timeline, and then added to it in ways that made the account irrefutable. The researcher, whose name was Simone, had been transferred to a different department 3 weeks after filing the memo. She had been told the transfer was a restructuring decision. Nora had met Simone once, briefly, in the corridor of the courthouse on the day she received the dismissal notice. They had not planned to be there at the same time. They had looked at each other with the particular recognition of two people who have been part of the same thing without having chosen to be. They had stood in the corridor for a few minutes and talked with the direct, spare economy of people who did not need to explain to each other what any of it had been like. Before they separated, Simone had said, almost as an aside, that she had always found it remarkable that the legal systems of the ancient world had contained, buried in their structure, so many of the same failures and the same corrections as the systems that claimed to have improved upon them. Nora had thought about that for a long time afterward. She had thought about it while writing the final chapter of her dissertation. She had thought about it, sitting at her kitchen table, the morning the acceptance letter from the journal arrived. She had thought about it in the small, specific way that you return to a thing that contains more than it initially appears to, pressing gently at its edges to see how far they extend. What she kept coming back to was not the Latin, not the courtroom, not the silence after. What she kept coming back to was the morning she had sat in a fluorescent room at 4 a.m. and started writing 3 pages with a borrowed pen on the back of a pamphlet about detainee rights. The correctness of the thing she was writing had been completely clear to her. The path between that correctness and anything resembling justice had been completely invisible. She had written it anyway. She had written it anyway because she had learned, in 4 years of studying the legal systems of dead civilizations, that the gap between truth and institutional recognition of truth had always been exactly this wide, and that the people who had managed to close it, even partially, even temporarily, had almost always been the ones who refused to accept the gap as the final word. The truth existed before anyone recognized it. It would exist after. The work was to hold it with enough precision that when someone finally looked, there was something real there to find. She had held it. Someone had looked. Something real had been found. That was not the whole story of justice. It was not even most of it. But it was the part that had happened, and it was enough to stand on, and she stood on it, and she built what she built. If this story stayed with you, share it. Somewhere right now, there is someone sitting in a fluorescent room with the truth in their hands, and no one yet willing to look at it. They deserve to know that looking is possible, that the gap between what is assumed and what is real can be closed, that the precise, patient, undefeated act of holding the truth carefully until someone with the standing to act on it finally arrives is not passive. It is the most powerful thing a person can do in a room that has already decided what they are. Share this, because stories like this one do not belong only to the people who lived them.